Hello, everyone, and welcome to our webinar on the new UAE Commercial Companies Law. The webinar is led by Bashir, Ahmed, and Abdus. Without any further ado, I will turn it over to Bashir and Samad, who will start the webinar and the discussion.
Thank you, Samra. Welcome, everybody. Today, we're going to discuss the new UAE Commercial Companies Law, which was promulgated last year. It comes into force this month. Companies law is probably one of the most discussed subjects of late, largely because of the changes in foreign ownership and essentially the dispensation with the 51% local ownership requirement. However, I've been asked to say a few words since I'm a lot older than the person next to me and I have more gray hair. I've been asked to say a few words about the history of the companies law. As you're aware, legislation on companies laws has been around since the 19th century in most parts of the world. For some reasons, it largely, this region was overlooked. And in fact, the UAE was created in 1971, still did not have a companies law. And the first companies law was actually promulgated in 1984. Prior to that, and even prior to the establishment of the UAE, companies were formed in this part of the world, but they were formed by Emiri decree. Now, that's a decree of the ruler of the relevant emirate establishing a company. So essentially, each company was established by a law particular to that company. There were also a number of partnerships, but these entities existed without any regulatory framework or any statutory framework. In 1984, the UAE finally got around, as I say, and promulgated its first companies law. Now, going from a situation where there was no companies law, this became quite a sophisticated attempt, I would say, in that it catered for 7 types of companies. There were various public and private joint stock companies, various partnerships were caught up with this, as well as the LLC, the limited liability company, which is the most common form. However, immediately after the law was promulgated in '84, it was immediately suspended. And the reason for that was largely that there was a disagreement between the individual emirates and the federal government as to the extent of authority that the emirates should have or that the center should have over various types of companies. And this took some 4 years to resolve. And in 1988, the companies law was reintroduced, shall we say. And the decision was that the federal government, the federal ministry would oversee public and private joint stock companies and branch offices of foreign companies, whereas the emirates would have primary authority over the establishment and regulation of partnerships and limited liability companies. So that's how we ended up with a companies law that was in force until 2015, when a new companies law was introduced, which didn't really make many changes. And in fact, there were several changes to the law straight after it was promulgated, again, which have resulted in now this new law coming in as quickly as 2021. I'll hand you over to Samad, and he'll talk about these in a bit more detail. Over to you.
Thank you, Bashir. Before we go into the details of the new law, I wanted to briefly summarize the key facts concerning this new piece of legislation. The new companies law has been promulgated as a federal decree law, and it's Federal Decree Law number 32 of 2021. It came into force on the 1st of January 2022, and it repeals and replaces the previous legislation on the subject, which, as Bashir mentioned, is Federal Law 2 of 2015. Now, importantly, the new legislation contains a saving provision for implementing regulations and guidance issued under the old law. And the new law provides that this implementing the secondary legislation, if any, subsists and continues to be in force until such time as it is replaced by new implementing regulations. So there is that transitional period and that transitional state that everyone should be aware of. Next slide, please. One of the most interesting features of this new legislation, and the one that I feel has been talked about and written about quite a bit, is the introduction of certain new types of corporate vehicles. And one of the new types of entities that has been introduced in the new legislation is a so-called special purpose vehicle. Now, bear in mind, this is not necessarily a new type of legal entity, but it is a way of describing a company and a special quality, if you will, given to a company established under the new companies law. Now, a special purpose vehicle is described in the new law as a company established for the purposes of ring fencing assets and liabilities. And furthermore, a company that is to be used for asset financing or otherwise for a financing related purpose. It's as yet unclear how a special purpose vehicle is to differ from, for example, a single shareholder limited liability company, which, as most of us know, is meant to offer limited liability to its single shareholder. The one difference is potentially the possibility for a special purpose vehicle to be exempt from the application of the new companies law. That is specified in Article 4.9 of the new law, and it is yet to be seen how such an exemption will be used for the purposes of using a special purpose vehicle. Next slide, please. The other type of entity that has been introduced for the very first time and one that's very interesting in the current climate is the special purpose acquisition company, or SPAC for short. Now, these, in summary, are companies that are listed on a public market and whose shares are traded on that market. However, the key difference is that this company does not have, at the time of listing, any business or operations or any particular intended target. The idea behind a SPAC is that those that invest in this company and buy its shares are giving the sponsor or the group that is proposing the listing a so-called blank check to undertake such acquisition or merger that they may decide is appropriate. The UAE government has, in line with international trends, seen it fit to bring this concept into this market. And we anticipate that it will be a positive step forward to encourage equity capital market development in this region. Now, a SPAC is required to be a public joint stock company. It's required to be listed on one of the two exchanges in this market. And in addition, the SPAC is required to comply with the relevant decisions of the Securities and Commodities Authority. In this case, the SCA has issued its decision number 1 of 2022, which specifically regulates a SPAC. Of course, a SPAC, in addition to a special purpose vehicle, should assist investors and existing businesses in the UAE in structuring transactions that they're looking to undertake. Next slide, please.
Just before we do that, some of this question has popped up. We've seen listings of a number of SPACs around the world. The UAE, I suppose we get to see our first listing. If someone is considering listing a SPAC in the UAE, what particular issues should they be looking at or considering?
Very good question, Bashir. The first issue I think that needs to be sort of assessed is which market within the UAE the SPAC is to be listed on. Now, of course, there's two markets that exist onshore in the UAE. The first being the ADX in Abu Dhabi, and the second being the DFM in Dubai. There are, however, also the financial free zones, and in the Dubai International Financial Center, we have NASDAQ Dubai, which is regulated by the Dubai Financial Services Authority. Now, of course, to the extent a SPAC is to be listed on NASDAQ Dubai, the rules and regulations issued by the DFSA will be relevant. And I do want to flag that there is a standalone and separate regime already in place for so-called SPAC listings on NASDAQ Dubai, and those have been promulgated by the DFSA. Separate rules, of course, have been issued by certain of the exchanges. So in addition to complying with regulations issued by the Securities and Commodities Authority, if you're looking at an onshore listing, you would need to consider the rules of the particular exchange on which you are looking at. And those rules and regulations may guide and have an effect on the decision-making process, because depending on the structure and the time frame of the transaction, one or more exchanges may be more attractive or be a better fit for the target audience of the SPAC. Next slide, please. There have also been a number of key changes concerning public joint stock companies. And one of the more interesting ones for me personally is the introduction of more detailed rules around spin-offs and demergers insofar as they relate to a PJSC. Now, the new companies law now sets out a broad framework for how a PJSC may divest of a particular business vertical, or how it may potentially split into more than one company, both of which might be listed and publicly traded. Now, again, in continuation of the trend that we've seen, the steer is very much to allow flexibility for investors to structure their proposed transactions as they wish, and to prevent hindrances insofar as the law is concerned in these types of transactions. The other noteworthy change is the ability for a public joint stock company to issue shares at a discount, subject, of course, to approval by the Securities and Commodities Authority. This was not previously possible, and I believe opens up an avenue for fundraising by public joint stock companies, again, giving them that additional bit of flexibility that they might need in turbulent times. The new law has also now removed the restriction on the par value of the shares of a public joint stock company. And so again, there is that trend towards offering as much flexibility as possible for those looking to raise money on the public markets. Finally, the new law has more detailed provisions concerning the appointment and remuneration of directors around PJSCs. Next slide, please. There have also been a number of noteworthy changes concerning limited liability companies, and perhaps the most interesting one for me personally is the reduction in the rate of contribution necessary for the statutory reserve. It used to be the case that all limited liability companies were required to set aside 10% or at least 10% of their annual profits and contribute those funds into a statutory reserve that had to be accumulated up to a particular point. That rate of contribution has been reduced from 10% to 5%. And this may offer some comfort to those companies that may want to use those additional funds towards capital expenditure and investment. There's also been flexibility introduced for quorum requirements of an LLC. In particular, there is now flexibility for no quorum requirements to apply where a shareholders meeting has been adjourned, meaning that a meeting was called, could not be held because not enough members attended, and then was re-adjourned for a later date. Now, this is an interesting development because it is not necessarily positive in every situation. The thing to bear in mind is that if in a particular entity, for example, a joint venture, you have very specific quorum requirements that you or all parties are required to adhere to, it is not necessarily conducive to have the law specify this additional flexibility. The parties may actually prefer that the very specific and high standards they've agreed to in relation to quorum should continue to apply. Unfortunately, the law does not specify that the parties can contract out of this requirement. And so this is something that parties to a joint venture, for example, should reflect upon and consider in planning their meeting arrangements going forward. There have also been changes to the rules around the terms of boards of managers to the extent they are relevant for a company. And these should be factored in planning for any relevant arrangements. Next slide, please.
At this stage, let me chip in again, Ahmed. You had mentioned that the new companies law provides a statutory basis for spin-offs, demergers, and so on. The fact that this law has been brought in just 5 years, 6 years after the previous law, and during that period, we've seen a lot of activity, I would say, particularly in Abu Dhabi Emirate, where we've seen a number of mergers. We've also seen some spin-offs, the most notable one being ADNOC's spin-off of its pipeline business. Do you see this law sufficient or addressing these kind of opportunities, should I say?
A very relevant issue, Bashir. I think what's happened in this particular instance is that those transactions were structured and agreed in a lacuna. And now the authorities have sought to fill that gap by creating a legislative framework. And I think what has happened is that best practices and the experience in those transactions has been drawn upon to create the statutory framework necessary to enable further transactions, such as the ones that have already taken place. So I do think this is a fairly positive development that should provide those looking to do these kinds of public transactions greater comfort in the enforceability and validity of what they're looking to do.
Thank you. That addresses my question.
Now, we would be remiss to ignore some of the related developments that have taken place at the same time or around the issuance of this new legislation. And one of the most noteworthy ones, and as Bashir mentioned, the most discussed certainly over the summer, has been the new foreign direct investment regime that has been introduced. There has been a relaxation of the UAE national ownership requirements that previously applied, and it is now possible for a foreign non-UAE national investor to own up to 100% of a UAE incorporated company. Now, I will add that the particular rules and the activities for which greater than 49% foreign ownership is permitted varies from emirate to emirate, and the emirate level licensing authorities have been given a broad degree of discretion to determine which activities they propose to allow for majority or greater foreign ownership. So it is important to consider the rules of the particular emirate and the licensing authority that has jurisdiction before proceeding with any business incorporation. Next slide, please. There's also been the creation of a new commercial register pursuant to Federal Decree 37 of 2021. This law calls for the creation of a unified, federal, and publicly searchable register for onshore companies and for those companies incorporated in most free zones. Of course, the DIFC and the ADGM free zones have their own publicly searchable registers already in place. Now, depending on how this development is implemented and how user-friendly and easily searchable this new register is, this could potentially be a landmark development, in particular for those that are looking to buy existing businesses in the UAE. Traditionally, one of the challenges for foreign parties looking to invest in the UAE has been the difficulty of doing due diligence and the limitations that apply in gathering information independently about a potential UAE target. Now, implementing regulations on this new register are still awaited, and it's yet to be seen how user-friendly and how comprehensive this new register is to be. but assuming it's implemented in the same spirit as the law intends, this could lead to much greater transparency and reduce difficulties faced by foreign acquirers in doing due diligence on UAE targets.
Could I just chip in there that this is not the first law on a commercial register that we've had in the UAE. We did have a law that was passed before you were born, more than 40 odd years ago. And that law also provided that for payment of a fee, I believe it was 2 dirhams, one could go and get an extract of the commercial register details of a company. However, what happened in practice was that when you went to the commercial registry department, offered to pay you 2 dirhams, they would ask you to bring a letter of authorization from the company that involved, or a power of attorney from that company. So that really negated the whole point of having a publicly accessible register. I suppose we'll have to wait and see how this one pans out, but hopefully it will be truly accessible and searchable.
Absolutely, Bashir. Let's wait and see how this development pans out.
Next slide, please.
Now, in terms of takeaways from this webinar, the issues to think about are, first and foremost, to consider whether the new statutory regime necessitates any changes to a company's constitutional document, so the Memorandum of Association, or in the case of PJSCs, the Articles of Association. There may be subtle changes that are needed for the internal corporate governance arrangements of a particular entity. And it's important to take stock of these changes in advance of holding any meetings or planning any future arrangements. Consideration also should be given to the newly available structures and mechanisms in considering new transactions in the UAE corporate landscape.
One of the questions that's already arisen is whether the new law requires companies, every single company, to amend its constitutional documents. If you recall, the 2015 law required all companies to amend their constitutional documents. In practice, this was not done, and the authorities then passed a regulation saying they were deemed to be amended to conform to the law, which raised a lot of questions as to how they were deemed and to what extent they were amended and so on. How does the new law address this point?
Bashir, the new law deals with this issue in exactly the same terms. If a company incorporated pursuant to the company's law, the old or the new, does not update its constitution to become compliant with the new law, it's deemed to be dissolved. And this has to take place within 1 year of the date on which the new law has taken effect, being, in this case, 1st January 2022. So again, it is important to take stock immediately and make the necessary changes to make sure that your business is compliant with the new law.
I think that that wraps up our presentation for today. Thank you, everyone, for attending, and we'll hand you back to Samra. Over to you.
Thank you, Bashir. Thank you, Samad. Thank you for this very informative presentation. And thank you, everyone, for joining us. Again, we will be sharing the slides and the webinar recording with everyone who attended the webinar. If you have any additional questions, please feel free to get in touch with Bashir or Samad directly by email. I'm sure a lot of you have their contact details, even their phone numbers, but you know, their email addresses were also displayed on the title page of the this presentation, of the PowerPoint presentation. So thank you again, and hope to see you at our next, or hope to see you virtually or physically at our next webinar or seminar. Thank you.